because you paid attention to all the details and you told the other side, hey, it's fish or cut bait right now. And I'm going to sue you if you don't get this resolved. And I'm going to get my attorney fees. I'm going to get a lot of interest. You're going to pay your attorney. You're going to pay my attorney. It's not a good result. So pay me what you owe me. And then at least at that point, let's say somebody is owed $100,000.
Right.
All right. At least maybe the other side will call and say, look, we're just really pressed. If we could get you $85,000 within the next 30 days, do we have a deal?
Right.
And then you say, yep.
Okay.
And you're done with it and you move on.
This is Eric Anderton, and you're listening to Construction Genius, a leadership masterclass. Thomas Edison said that genius is 1% inspiration and 99% perspiration. If you're a construction leader, you know all about the perspiration, and this show is all about the 1% inspiration that you can add to your hard work to help you to improve your leadership. Welcome to Construction Genius. This is Eric Anderton. My guest today is Bill Porter, the CEO of Porter Law Group out of Sacramento, California. And we have a wide-ranging discussion today about contract law as it pertains to construction companies. And first, we begin our conversation by talking about how Bill got into the legal field. Bill has over 30 years of experience working with construction companies. He's very sophisticated, but explains the issues in a very clear way. And you're going to get great value from taking the time to listen to this interview here today. I appreciate you listening. I appreciate you sharing this interview also with others if you find it something of value. I've been getting great feedback from people in terms of the episodes and the interviews that we're doing here on Construction Genius. I appreciate that feedback, and I thank you for listening. Enjoy the interview.
I was a parking attendant in San Francisco when I was in college, and a cashier too. And these two guys came in and robbed me, and I gave them the money, but they punched me, I thought, and actually they had stabbed me. And then they parked across the street. I just went over and got their license. I called the cops. The cops caught them, about a mile away, and they had all the things in there that, like, the bag from which had the name of the company I worked for, exactly how much money I knew they took because I was closing down. It was like $19 in ones and a $5 bill and $11 in quarters, something like that.
Wow.
And they caught him. Then I had to go testify. And then I got all involved in the court process.
Right.
And I thought that was really interesting. And I talked to the assistant district attorney, and he encouraged me. And ultimately then, a few years later, I decided to take my LSAT and apply to law school. And fortunately, I got into a school here in town where I was from, McGeorge. And then I went to law school there. So
that's great. You play any rugby at McGeorge?
No, I didn't.
Yeah, when I was in college, I went to Humboldt, and we used to play against McGeorge.
Oh, yeah. No kidding.
Yeah.
No, I would play a little baseball, but just kind of for fun, not for competition. We just play, regularly among ourselves. I was on a what was called Owens California Forms and Procedures. It was a kind of a civil procedure treatise. And then we would get together with some of the law review people, and we'd go out and we'd have, baseball games. It was fun.
That's interesting. You said you got stabbed. Where did you get stabbed?
In my chest.
In your chest?
Yeah. And so I was there, and I go back to the booth and I call 911, and I'm going, what's all this liquid all over me? And I stick my hand in my shirt, and oh my God, I look at my hand and it's covered with blood, and I go, oh, I guess I got stabbed. I didn't think they stabbed me. I thought they just punched me, but that was kind of unnecessarily brutal of them to do.
Right.
So ultimately they were convicted, and they got 3 to 5 years. But it exposed me to the court process, and I thought that was really interesting. And so I think that was one of the things that pushed me in that direction.
Really?
Yeah. I have no. I do now, but at the time I had no other members of my family who were in the legal field at all, and so it just kind of interested me, and I went in that direction.
That's interesting. Yeah, when I was a kid. Well, I wasn't a kid. I was 15. I was in a nightclub in England, and because that's what you do in England when you're 15, is you go to nightclubs. And me and my friend were coming out, and there's these guys out there, and for whatever reason, they started chasing us. So I got stabbed.
Oh, no kidding.
Yeah. I got jumped by like these 10 guys. I don't know if you see the scars on my face. You can't see them because I got a beard.
Yeah, but okay.
Yeah, but I got stabbed when I was 15. So that was pretty interesting.
What happened to those guys? Were you able to anyone catch them?
No one caught them. The police did a little bit of inquiry to it, but I couldn't really identify them.
Yeah.
And it's interesting because they have like a victims compensation board in England.
Oh, no
So
kidding.
I moved to America right after that, and a couple of years later, I actually ended up getting about $10,000 and bought my first car as a result of that.
That's handy. That's worth a bit of money in those days.
I know. I mean, $10,000 back in the 80s, early 90s, that wasn't too bad.
Yeah, indeed.
Yeah. But it's funny. I always think about it. If the type of guys that I was involved that jumped me and the situation that I was in, if I was in America, they may likely have had a gun as opposed to a knife.
It may be true. And then you wonder, well, what happened to those guys? Did they right their ways? Did they victimize other people and eventually go off to jail?
I know. So I think about that sometimes. I'm not, I don't like feel bitter towards them or anything because of so many years ago and, you're just a kid and everything. But it's interesting when you think about that. If people, you think about the guys who went to jail for what they did to you, you wonder what happened to them. It's interesting,
well, I know their names,
right?
But I often wonder whether they would seek me out.
Yeah.
But as far as I know, they never have.
Yeah.
And I moved from where I was, San Francisco at the time, and now I'm here, and they were older than me, so I think that they got that stuff out of their system if they're alive.
Yeah, it's interesting, huh? It's interesting the choices that people make at different parts in their lives, and sometimes the immature choice that we make has a much deeper impact on us than perhaps we thought it would.
Yeah. It's true. And choices that you make start from a very early age. We have 2 kids, and they're just off to college now.
Right.
But we've always taught them that the importance of the decisions they make from a very early age, whether you do your homework, whether you get involved in community organizations, the decisions you make when you're really little, everything adds on to the next thing. And if you do good things, then it leads to more good things. And pretty soon you find yourself in a place where you never expected you would be, and where people who from an early age didn't make good decisions never end up. And so it's all good. Do good things and stay involved, and that's a good pathway.
It's interesting, that idea of incremental progress, because we live in an instant gratification world. But from building a business, I know from building a business, I know my clients and your clients who are in construction. Any progress that's lasting tends to be built over time through those small choices that we make.
Absolutely. Every organization I've been involved in over the years, it has started with a small idea and a small decision that just takes you down a different pathway. And pretty soon you find out that you're trailblazing. Yeah. And then you bring in people behind you, and then before you know it, you've created something new.
That's interesting.
Yeah.
So you graduated from McGeorge Law School, and did you begin practicing law right away?
Pretty much. Yeah. I worked for a wrongful termination and discrimination plaintiffs firm, which is not what I do now.
Right.
But some of what we do now is that although we do a lot of construction law, we also do employment law and some regular general business law. But the things I learned as a plaintiff's wrongful termination discrimination attorney have really helped me to help employers nowadays to draft policies and procedures to benefit them. And to honestly, I have a different play on that because I was a plaintiff's attorney. So I'll draft policies that, in fact, it's like the secret ingredient is that it will discourage, let's say, disgruntled employees from or it'll discourage attorneys from accepting their cases.
Right.
Because if you do certain things right in the practices and policies, then an unhappy, rightfully or wrongfully unhappy employee will go to an attorney. The attorney will say, show me the paperwork from your work, your contract, your policies, your procedures manual, all that. Show that to me. And then that attorney will generally say, I don't think I'm interested in taking this case. Why don't you go see Joe down the street? He's another attorney. He might like to help you out. And then that guy goes and sees Joe. Joe looks at the same things and says, Mary over there across the way, she could maybe help you. I'm not interested in the case. And then the guy goes to Mary or whoever all the other attorneys are they go to, and nobody wants to take the case. And then you never hear about the unhappy employee who wants to bring an action against you because they never find an attorney to help them out.
Yeah, it's interesting because I find myself so often, I talk to my clients that I work with in construction, and I just think of this one general contractor who has an employee who's basically abusing the paternal leave laws, to his own advantage.
Yeah.
And the employer is sort of hamstrung because they have to work within the rules in order not to get some sort of HR suit or whatever the case is against him. And you can just tell that this employee is not a high performer, someone that you want to keep in the organization, and they're just kind of working the system.
You're often damned if you do and damned if you don't. I know of one case where there was an employee, and it was a high-profile case. It was years ago, though, and the facts might be familiar to anybody who would be listening to this, but the person would go to staff meetings at this employer and would take notes and would actually have different colored pens for everything that was said for each person, and then would misstate intentionally through all these meetings. Things that were said would blow them out of proportion, all for the benefit of making everyone in that room look bad and making them look good. And then they brought a lawsuit after that.
Right.
It was a terrible thing, and it caused a lot of havoc. And then that same person, when that was resolved, went on to another employer, a high profile employer, and did the same thing.
Yeah.
And sued that employer also.
Yep.
And so for some people, that's a way of life.
That really speaks to the one of the fundamental keys to success in business is who you choose to do business with and who you choose to employ.
Absolutely.
And so as we think about your work with construction companies, how did you get into working with construction companies in the first place?
Well, I transitioned to a firm which no longer exists, but it was Stanton, K. and Watson, and they did a lot of construction law and they did employment law.
Right.
And I was getting much involved in construction at the time, and there was an attorney, an excellent attorney by the name of Elmer Malakoff, who I worked with, and he was well known for things like mechanics lien, stop notices, bond claims, all types of construction claims, and he would put on seminars for industry groups. And he had done this for a number of years. I'd gone to some of the seminars to learn the small details of construction claims. And then, unfortunately, suddenly he died.
Huh.
And there were seminars scheduled, and people were going to be attending, and somebody had to do it. And this is one of the decisions you make in life, is that you say, you know what, all these people can't be let down, and they've taken their afternoon off to go to one of these seminars, so I guess I'm going to go do it. And I just went and did it.
Interesting.
And from that point forward, I kind of developed that program to give it more and more meat and detail. And flowing from that, then I did a video series. So it's all a progression from one thing to the next. And it wasn't my intention to go in the direction that I did at the time. But when I went and did the first of those seminars, I thought to myself, this is pretty cool. I like this. I think these people really appreciated the time I spent with them and the information I gave them.
Right.
And I wasn't even thinking of it as a marketing device either.
Right.
But it became one, I think.
Right.
And then...
and where's that video? I know the video series. What is it?
It's appliedlegal.com.
Yep, that's right. When you work with the larger contractors all the way through to the smaller contractors, what are some of the repetitive challenges that contractors have in light of the legal issues that you specialize in? Okay.
Well, one thing that I will mention, I think, at the outset, that isn't really a difference between the problems that the different types of entities encounter, but there is one common problem, and I think that is in all of the law and in all of business, and that is people.
Okay.
All the problems, all the law, all the preliminary 20-day notices, the 30 days for a mechanics lien, or 60 if you're a direct contractor, all the legal rules that I could discuss don't matter if you don't get the people thing down right. So I will have huge contractors who have a dispute because there's one person at the owner or the public entity who is quite unreasonable. Right. And there's no way to get along with them. And at the same time, I will have people who do a small job for one person, maybe a residential job.
Yep.
And and they're never going to be satisfied no matter what.
Right.
And it's the same thing in a multi-million-dollar project or a $50,000 project. It's the same thing. It's people. And that's the common thing. Now, the things that commonly cause problems that people come to me for is if they don't I think it comes down to educating themselves on the rules that they have to follow.
Right.
Like, for example, if you're working on a construction project and you're not getting paid, then, well, there's a contractual issue. Can I just stop working?
Right.
And it depends what's in the contract. Usually, you have to keep working and preserve your construction claim rights and just keep going. Otherwise, all the projects would end whenever anybody had a dispute, and then that wouldn't work. So usually contracts say you have to keep going. But then the problem occurs when people don't protect their rights from the outset. Like, for example, subcontractors and suppliers, they always have to send out a preliminary 20-day notice.
Right.
They have to do this. Otherwise, they will not have a right to a mechanic's lien, stop payment notice, or bond claim. They won't be able to protect their rights.
So the preliminary 20-day notice is kind of like waving the flag to start the process.
Yeah. And in fact, if you're among those who are required to do that, to protect yourself, if you don't send a preliminary 20-day notice, then there's a law that says that you can be subject to discipline by the Contractor State License Board, who issues licenses to contractors. So
do you see even what you would consider to be sophisticated contractors miss details in terms of the contracts that they're signing, or what do you tend to see there?
Yeah, I see people that I see the larger contractors having very well developed contracts,
right?
And I see subcontractors just signing them willy-nilly. Now, those big contracts, they are at the edge of what is allowed to be in a contract.
Right.
But they cautiously have managed to draft their, like, let's say, a defense and indemnity clause in the contract in such a way that it is not a type 1, which is not allowed anymore, and it just barely is okay. Or there will be something which we call a pay if paid clause.
Right.
And there's some rules on that. And what happened is that there was a case called, I think it was Clark versus Safeco, Supreme Court case a few years ago, California Supreme Court. And it said that you cannot have in your contract a clause that says, if I don't get paid, I don't have to pay you.
Right.
Okay, so that was outlawed. And that used to be in all the contracts for a long time. And it was a very unfair clause. And the court said, no, that's unfair for various legal reasons, including the state constitution. They said that wasn't going to be allowed. So now people have taken their the same clause that says that I don't have to pay you if I don't get paid, and they've changed it to say, well, I'm not going to pay you right away. What's going to happen is that I'll have a dispute with the owner, me and the direct contractor, the prime contractor, and you're going to have to wait for me to resolve my entire dispute with the owner before I have to pay you. And so that can be years. Now, the problem in this regard, in clauses like this, is that subcontractors, of which there are more subcontractors than general contractors, it's the way it is.
Yep.
They won't even take a stab at revising any of those contract terms. For example, on something like that, on I don't have to pay you, maybe you could add in something like, as long as it doesn't exceed 6 months, or something reasonable, to get past the issue, because otherwise they could be stuck for years not getting paid, and it can destroy their business if they're out all that money.
Yeah, it's very interesting. I'm just reflecting on a company that I know who's in a dispute with a owner, and that dispute, in combination with the fact that he's got a bunch of outstanding retention and some accounts receivable that's outstanding, has just about bankrupted this organization.
Yeah.
And this is a subcontractor that's been very successful for many years, but because of the people issue. So I want to come back to that. What advice do you give to your clients in light of the people issue that causes many of these contractual difficulties and this unreasonableness and this conflict?
I think that what people need to do is, in as diplomatic and pleasant a way as possible, kind of nip that in the bud. And sometimes you have to slap a hand a little bit, and you have to see what works. Everybody's personality is different. And sometimes if you approach it with, hey, we're kind of getting off track here, let's get ourselves back on track, and you apply the light personal touch, sometimes the beast on the other side can be tamed a little bit, and will deflect their energies and attentions to something else and not you. And so it's a diplomatic thing that depends on the particular situation.
And is this pre-contract as you're talking about, or after the contract's signed?
I think usually those personality problems arise after the contract is signed. Sometimes too, you have people that are involved that are kind of new. I don't know. They're just out of college and they think they know everything, but they don't know a lot of things.
It's true, isn't it?
And it's a lot of the people things too.
Yeah.
And so
they not only don't really know construction, they don't know the people part because they don't have the experience.
Yeah, they know the book stuff on construction, but they have to learn the practical aspects of construction, which are decades in the making.
So how do you counsel your subcontractors? Let's just go step by step. As they're in contract negotiations, perhaps they're looking at a sweet project that's a good fit for them in terms of their competencies, but perhaps they haven't worked with the GC before or the owner. Mm-hmm. How do you counsel your subcontractors in terms of how they approach a project in a pre-contract phase?
Well, the very first thing is get into that contract as soon as you can. There's a seminar I do. I will go through a contract and I will say, okay, here's this clause. Here's why this clause is terrible for you. And here's different ways that you can edit it reasonably. Right. And then you have to figure, okay, if I do a huge number of edits, they're just going to reject the whole thing. But sometimes if you do enough edits, they will say, okay, let's work with them on some of these because they want to get the contract done and out of the way. Right. And then if you can get enough things, and I think this really helps to let people know that you're not a rollover. Right. And you're paying attention to this right from the beginning and that you know what you're doing. Then they're less likely to try to pull things over on you and mess with you. And then you just got to keep on top of it. You need a good contract administrator. You need good backup people in the office. That's very important from a very early stage. But it starts with negotiating the terms of your contract as good as you can. There's also another factor, and this is a factor that is also decades in the making. It is that gut feeling that you get in your stomach, that inkling that, and people come to me all the time with this and they say, when I met these people and I was going to do work for them, I had that feeling it wasn't going to come out right, but the profit margin looked good. And I deceived myself and my own need to keep my employees working and make some money and make a living kind of got in the way of my judgment. And now here I am in your office 2 years later. It wasn't profitable. Everything went wrong. The people on the other side, they didn't know what they were doing. They were dumping things on me that were not my responsibility. And now I lay awake at night, sleepless, worried about this thing, and I'm not getting paid. Everybody's unhappy. And I knew it from the beginning that this was going to be a mess, and I didn't listen to my own instincts. People need to listen to their instincts sometimes and just walk away at the beginning. That's
so fundamental because in construction, as you know, as I know my audience knows, once you sign that contract, you're really putting yourself on the line there. You're putting your personal wealth on the line. You're putting your blood, sweat, and tears on the line. And that following that gut instinct is something very interesting. But what I picked up in your earlier comments was the psychology of negotiating as you're going in, where you're positioning yourself as someone who has a backbone, but you're not positioning yourself as someone who's unreasonable.
Absolutely. Yeah. Yeah. And you want to allow the other person to assume the same role. And that's a professionalism that develops between the two of you. And another aspect of all that is that some things need to be in writing to protect yourself in the long run, and other things don't.
What is an example of something that doesn't need to be in writing in your experience?
Well, I think it's something that reflects poorly on the other side, and maybe on an employee of the other side. So you would call and you'd say to a higher level of management, you'd say, your guy out there, so-and-so, he's doing this and that, and I didn't want to put it in writing because I don't want to, reflect on it, but I want to talk to you about it and see if you can do something to kind of get us back on track, because if we don't get back on track with the way that this job should run, we're all going to have a problem. And I think it's kind of flowing from that person. Now, if you put that in writing, then that's some kind of, it's like evidence that can be used at a later time. Right. But maybe one of the things you need in that conversation is, listen, please don't write me back to reiterate what I said, because I'm calling you because I don't want it necessarily to be in writing. Yeah. And we're just trying to talk about this and work it all out. But on the other hand, you do need to keep many things in writing. When things start going bad, then sometimes you need your attorney to ghostwrite things for you, right, or run things by your attorney and see if it's going to be okay. And then you need to start documenting things. If it's going off the rails, you need to show who's to blame for it. And if it's you that's to blame or your organization, then you need to own up to it and fix it yourself. If you're in the wrong, you need to take care of it. But if the other side is in the wrong and they won't adjust, well, then it's time to start documenting things. And you need to do that because it's an old saying among attorneys, he who has the most writings wins, right. Something like that.
Yeah.
And it's kind of true. But when it gets like that, it becomes evident to everybody that, this is going bad. And then it becomes more difficult to fix. But sometimes you can still fix it.
What do you think are some of the key qualities of successful attorneys in the construction field for contractors to look for? What should they be looking for when they're looking to work with an attorney?
I think probably let's say for a construction attorney is involvement in the industry and resources on their firm website. But among attorneys, I'll tell you this is that, also another thing is if you can't use a particular attorney, maybe because of a conflict of interest, then ask them, who would you go to help me?
Right.
Because I'll tell you, let's say in this region, there are a number of people who specialize in this area and we all know each other.
Right.
And we know that we can't pull the wool over each other's eyes. We know that, okay, let's delve into the facts, figure out what they are, apply the law, and discuss this among ourselves, and then get it resolved. I have found that when you have a known and reputable construction attorney on one side and a guy he's had 5 or 6 or 10 cases with over the years, then those two guys can just sit down and say, okay, what's the right thing here? Where did this go wrong? Who's right? Who's wrong? How does the dollar figures lay out on this? And how can we get this resolved in the next 2 days?
Yep.
Instead of you get some, not to disparage young attorneys or anything, but you get some young attorney who's not involved in this kind of, and they have a different philosophy of cases sometimes, and they're just thinking of, unfortunately, I think some attorneys they churn the situation, and they're just billing time when they could better put their time in like two professionals that know each other to say, okay, let's get this done, because that is in the best interest of the client. And whereas one guy in a couple of days can resolve the issue with this other attorney, there's another guy who will just say, okay, let's file a lawsuit. Let's fight this out for 3 years. You're going to pay a couple $100,000 in attorney fees. You are also. And then 2 years from now, right before the trial date, we're going to settle the case. And then where are you going to be? You're going to be exactly the same place that those two guys would have figured out, those two professionals, in a couple of days, except that it's going to be 2 years later and it's going to be $100,000 out of your pocket, and you're going to get the exact same deal at that time.
We talked about at the very beginning the importance of people and how a lot of these conflicts come because of people conflicts, relationship conflicts. So if I'm a contractor, I not only have to be able to identify the right types of clients that I want to work with, I not only have to identify the types of people who I want to work for me, but then when it comes to services like an attorney or like an insurance broker, I have to understand myself and find a match with an outside service provider who is aligned with me in terms of my values and the way that I do business.
Yes, that's true. And what I find works best and is very profitable for a number of companies, both contractors and subcontractors, is that they have a long-lasting relationship over many projects. So a contractor will find a bunch of subs that they go through and oh God, this is a great plumber, and they communicate well. We're on the same page. They know what I want. I know what they want. We know how to make this work. I don't have to worry about them. And then they find a good electrician, a good roofer, a good concrete guy, all the sub trades, and they work with them. And then projects go really smoothly. They never have a problem, and it's wonderful. Then something happens. Someone can't work on a project because their capacity is maxed with other projects, and you have to get another guy in that trade. And then you're kind of testing them out and seeing how it goes. And sometimes that does work out and sometimes it doesn't work out. But the best thing is the relationships. If you have good long-term relationships, like a contractor I know, I don't think they'd mind if I said their name, Unger Construction. I worked with them for many years.
Nice.
And they have a group of subs. I drafted their contract years ago. It's a fair contract. They wanted a fair contract. And they have a lot of subcontractors who they work very well with, and things go smoothly. And other than an occasional bit of advice here and there, they're rarely, if ever, involved in litigation matters. And that's wonderful.
It seems like you might have the opportunity as an attorney to, with the right contractors and the right subcontractors, to almost sit on both sides of the table and craft contracts that are reasonable to both sides and would minimize the likelihood of litigation.
Yeah, it's true. Sometimes when you make a contract that is really stringent and near the edge of what's allowed, it might cause a problem later down the line.
Right.
And you might have disputes that arise. But if you have, let's say, a very fair indemnity clause, that goes a long way with subcontractors. They see it and they go, wow, this is a fair one. It's not like the terrible one that we had last year from that terrible contractor we worked for. This is quite reasonable. And it just kind of sets the stage for a good relationship to begin. And I think that's important.
If you could give us the top 5 pieces of advice, 3 to 5 pieces of advice that you give in your seminars that people could say, yeah, that one thing, that has saved me hundreds of thousands of dollars. What would that be?
So I teach the attendees a number of things that they need to do. So they have a dispute with the contractor.
Right.
And they're not getting paid. And then when it comes to the point where it has to be done, maybe they're going to record a mechanics lien.
Right.
Or send out a stop payment notice or a payment bond claim. And then the next thing that happens on the other side of the equation, let's say the owner or the direct contractor, the prime contractor, they will say, okay, these guys did a lien. And I know that there's a 90-day deadline on filing a lawsuit. A lot of people don't file a lawsuit and they miss the deadline and then their lien is dead.
Right.
And why don't we just wait and see if their lien is going to die? So then at that point, that's just one aspect of it. And then there's another thing that's a prompt payment remedy where, let's say if the owner doesn't pay the contractor or the contractor doesn't pay the subcontractor after they get paid for the subcontractor's work, there's these prompt payment remedies where you can get anywhere from 2% a month, which is 24% a year, to 2% plus your contractual rate of 1.5% a month, which is 42% a year, plus your attorney fees. And so you add these things together. And then what you do is you send out a letter and it reads something like this. Dear contractor, we are at the juncture where we have to decide what to do. First of all, I have a mechanics lien. Please don't hold it in the back of your mind that I am going to miss my deadline for filing my lawsuit. Right. I will file it. It's 90 days. My lawsuit is this date. And in fact, I'm not going to wait the 90 days. If you don't respond in 10 days, I'm going to file it now because there's no use wasting time if you're not going to deal with me. Also, there's an attorney fee clause in our contract. And so I know that I am correct on these issues and you're holding out, hoping to gain some advantage through time. So what's going to happen is that I'll file the lawsuit and we will go through the process. Now then, you will be paying your attorney and you'll be paying my attorney in the end. You'll be paying both sides' attorneys. So I want you to know that. Also, here's the prompt payment remedies. So in addition to paying my attorney fees and paying me what you owe me, you're going to pay me under this statute here 2% a month. This other statute here, you're going to pay me 2% a month plus the interest rate that's stated in our contract, which is 1.5% a month, let's just say. And then, okay, you're going to be paying me 3.5% a month, 42% a year. That's fine. I'm just warning you so you don't gripe about it later. Okay? And then so by doing this, you're the squeaky wheel that gets the grease. Right. So when someone's not paying you, they're probably not paying other people. Right. So it's a psychological thing. And the contractor, or it may be the owner in some cases, says, you know what? Why don't we get these guys taken care of? That's right. They're going to be a thorn in our side. They know what they're doing. Yep. We're going to have a lawsuit in the next month or so, 10 days to 90 days. It's coming if we don't get this resolved. And then you're the squeaky wheel that gets the grease because you paid attention to all the details and you told the other side, hey, you know, it's fish or cut bait right now. And I'm going to sue you if you don't get this resolved. And I'm going to get my attorney fees. I'm going to get a lot of interest. You're going to pay your attorney. You're going to pay my attorney. It's not a good result. So pay me what you owe me. And then at least at that point, you know, let's say somebody is owed $100,000. Right. All right. At least maybe the other side will call and say, look, we're just really pressed. If we could get you $85,000 within the next 30 days. Do we have a deal?
Right.
And then you say, yep.
Okay.
And you're done with it and you move on.
Just to summarize some of the things we've been talking about here, the fundamental foundation of a healthy business is the quality of the relationships that you have with the people that you choose to do business with. Mm-hmm. And from a legal standpoint, the real sense that I'm getting from you is that contractors need to take the initiative to understand the contracts that they're signing.
Absolutely.
And then to negotiate in good faith with the general contractor or the client in order to get the most favorable terms possible.
Within fairness.
Yes.
To both sides.
Yes.
Professional fairness. And you need to know all your remedies in case it doesn't work out.
Yeah, see, that's the thing. So there's and that's the thing is there's this idea of attention to detail, mm-hmm. and then being willing to take the initiative and not hope for the best.
Truly.
Yeah.
Yes.
But then also
you miss your deadline sitting around hoping.
Yeah. But then another piece that you brought out, which I really appreciated, was this sense of negotiating savvy and understanding of human psychology, in the sense that you're not necessarily bringing the hammer to the first conversation.
Right.
You're speaking softly to begin with. You're not necessarily putting everything in writing to begin with, just because you want to see where the other party is and if mm-hmm. you can resolve something without having to raise the stakes, so to speak.
It's Churchill's statement from your birth country: speak softly and carry a big stick.
There you go. I really get the sense that if you want to be successful in construction, you have to play long-term games with long-term people.
Yeah, serious people.
And not only the people, your clients, but then also the outside help that you bring in terms of the service providers, such as an attorney, who understand the construction game and who can help you through the ups and downs that occur in the different projects that you might build over the years.
Yeah, that's true. And what you need to do is have a good relationship with your attorney, bring them in on the little things before they get out of control, and keep that relationship going. And for an attorney, for a construction attorney, I suppose in other trades as well, but people don't call you unless they really need your help right at that moment.
Yeah.
And one of the things I try to do is respond to the client almost immediately.
Right.
Because it's got to get done anyway. The best way to do work, I think, in this profession is to get it done as quickly as possible, because that's when people want it.
Right.
I know a lot of attorneys, I hear complaints, and we don't do it here because we always focus on responding quickly, but that they get back to them a couple days later. And in a couple of days, a lot of things can happen. I was in South Lake Tahoe yesterday. Yep. And so a client called me and or emailed me and said, I need an interpretation of this contract clause because it's causing us a lot of problems.
Right.
And it had to do with a joint venture and how things had to be billed and what the law says and what this public entity can force on us. And I looked at the clause and I looked at some other clauses. And then at the time I said, hey, look, I will be back later this afternoon after I drive back down the hill from South Lake Tahoe. And I'll get right on it. And as soon as I got in the office, although I was tired as heck from presenting and getting up at 5 a.m. and doing all the driving and 3 hours of presenting. But as soon as I got in, I looked over everything and I looked at some of the law and I looked at the contract clause and I looked at the position of the public entity owner. And I said, no, they're wrong on all this stuff.
Right.
And then I sent them my opinion and how I arrived at it. And I did some quotes out of the contract and said, this doesn't say anything like what they said. And they were wrong. And then this morning I get a note from the client that says, oh, hey, the public entity backed off all that stuff that they wanted to force on us, which would have cost us, an extra $100,000 to administer.
That's beautiful.
And so, but it was moving quickly.
Yes.
And not letting it fester and,
yes.
and get bad. So I think that's something for any attorney to understand about their clients. They want the help now. And for clients, they want to get an attorney who does respond to them quickly and in a way that they can easily understand without getting too technical.
Yeah, it's interesting because if you're a contractor and you're going to grind for your clients to complete a project on time, you should be working with service providers who are willing to step up and provide that same sort of level of service to you. Bill, I really enjoyed this conversation. I have a question that I like to ask my guests, and especially my first-time guests. What is your favorite restaurant that you would like to recommend to our audience?
Oh, here in town?
Sure. We're here in Sacramento. Yeah, go for it.
Okay. I love Ella's.
Uh-huh.
Okay. And if you do go there, they have a very unique and special gin and tonic.
Oh, no way.
Oh, they do. And they get their I forget what the quinine type additive that they put in there. They get that from some exotic location, and they make a really nice drink. I like that, and it's a fantastic restaurant as well. And also, one of my clients built it. And then another little place that I really like is near the corner of Fair Oaks Boulevard and Marconi. It's kind of tucked back in there. Uh-huh. It's a Mexican place called El Papagayo.
Oh, interesting.
Okay, and it's just a little place.
Interesting.
I think they got a new chef about a year ago. Just a little place, and their crispy American style tacos are really good. I just love them, and they're reasonable, and the people in there are fine people. But it's just a little tucked away place that I like to go to, and as our kids grew up, that was our special place that we would go to take them, and we always enjoyed going there.
That's beautiful. So we got the crispy American tacos and the gin and tonic downtown at Ella's.
Yeah. I think those are two pretty good ones to go to.
Awesome. Well, I'll make sure to put a link in the show notes to both of those places. I'll also put a link to your website and the video series.
Yeah, appliedlegal.com.
Yeah, absolutely.
Bill, and Porter Law Group. Inc.
Porter Law Group. Yeah, excellent. I really appreciate you taking the time, Bill. I think we've got some great insights that my audience can take action on, and I do wish you the best in your business.
Well, thank you, Eric. I really enjoyed spending the time with you today, and I hope the information I gave might be of interest to your listeners.
Absolutely. I know it will be. Thank you.
Thank you for listening to this episode of Construction Genius. Hope you found that 1% of inspiration to help you in the next few days. If you like the show, please give us a 5-star review on iTunes, share it with other construction leaders who you think would benefit, and always remember that the show is brought to you by Kick-Ass Meetings. I've been working with construction leaders since 2004, teaching them how to run extremely effective problem-solving meetings that gets their people collaborating, taps into their creativity, and to get yourself a free copy of the Kick-Ass Meeting Report, go to www.ericanderton.com/kickassmeetings. Grab yourself that free report, read it, use it in your business. You'll find it extremely useful. And thanks again for listening.